But most importantly, the prosecutor has to prove that the defendant in this case is the one who caused the accident or who is at fault for the accident. Let's suppose that I am drunk at .20 BAC and I'm driving through an intersection on a green light and a third party runs the red light and T-bones me, and that person suffers the major life-threatening injury. Can I be charged with a DUI with great bodily injury? The answer is no. The answer is that I may be liable for drunk driving, but I'm not liable for a DUI with injury. This is because I'm not the one at fault for the accident. Just because I'm intoxicated and involved in an accident does not necessarily mean that I am that person at fault. However, in reality, the California Highway Patrol investigates these types of accidents and finds that somebody was drinking. They almost always point the finger at that person alone and rush to judgment. This doesn't only result in a rush to judgment, but they end up doing a sloppy investigation because they usually assume that the person who had been drinking alcohol is at fault. It is not always the case, so that is why we always do an independent accident reconstructionist and hire one for this purpose. That expert we trust. In quite a few cases, we find that the other person was at fault. We encourage you to tell us at the law offices of Michael A. Fiumara your story, so that we may do a preliminary investigation and help you get your charges and either greatly reduced or dismissed. If we have to go to trial, we will, and we'll get a full acquittal.